think I know most of the people here, so welcome. Um, as you may know, this was actually started with a foundation of Nichole decided to kind of pay it forward and started teaching how to be successful in multifamily 10 or 11 years ago. And then she was doing it live, and then COVID hit, and right before COVID, we decided to actually go online. So even though it was a 4-day class, everything was built back from the ground up. So now it's almost double the amount of information online. And we have not done a live 4-day class since, like I said, pre-COVID. And we're actually having one the beginning of November, 2nd, 3rd, 4th, and 5th, right here in Baltimore at one of the convention centers. And with that, obviously you'll also get the online class as well, but it's kind of a one-time shot. So if you're in the area, or even if you're out of the area and you want to fly in, it's actually at a hotel, so you can stay in the hotel. But actually it's kind of a giveaway price. For you guys on Teaching Tuesday, it's $1,500, and that's the class and the live class. And if you're not on Teaching Tuesdays, then it's $2,000. So if you have an interest, just shoot me an email and I'll send you the link for the reduced price. And if you had not had a chance to actually watch Nichole teach in person, it is quite the event and you will learn an enormous amount. I don't mean that in a bad way, Nichole. It's a lot of fun. It's a lot of fun. So having said that, I'll go ahead and pass it over to you, Nichole.
Okay, just a sec. If something just popped up on my computer that I need to get out.
Okay.
All right, so we are going to be talking about 3 or 4 kind of specific ways that you can use land trusts that are not kind of the typical thing. So last week, well, 2 weeks ago, we started with some of the basics of land trusts. And then this week, we're going to talk about 3 or 4 things that that land trusts can do for you that are probably not so well known, but have a lot of benefit to them. So one of the things I do want to do is to kind of go back and just hit with one slide, kind of bring us all up to what we talked about last week. So a land trust is created by an agreement, and then you have to deed the property into the trust. So a land trust only holds the actual property. And so when you form a land trust, both the legal and the equitable title move to the trustee. So once the trust is formed and the trustee is on title, they have the deed. And so you no longer own that property. You are the beneficiary of the trust. And since land trusts only hold property, when you are the beneficiary of the trust, you now are the owner of a personal property trust. That has ramifications that we're going to talk about just a bit later. But a land trust only holds property. Once you have put something into a trust and given the title and the equitable interest over to the trustee, you no longer own that property, but you are the beneficiary of the property. Okay. So legal title means just that you have the deed, and whoever has the deed has able to make all of the decisions for the property. So they can sell the property if they want. They're only supposed to do that at your direction, but they have legal title. They also have equitable title. So equitable title means they have the right to the property. So if you think about it, that when one has equitable title, you have the right to have the full legal title. So when an example of this is when you sign a purchase and sale agreement to buy something, now you have, once that both people have signed that contract, you now have equitable title to that property. All right. So it's not title, I'm sorry, you have equitable interest or equitable title in the property, which means that you have the right to get the legal title. Okay. So a trustee has both legal and equitable title. And so I just want us to understand that. There is a trustee, there is the beneficiary of the trust, which is typically an LLC, and you are the owner of the LLC, or you own a certain amount of the LLC, right? Land trusts only provide privacy. They have no protection against the entity itself. So they have no actual protection in a legal sense. That's why you don't ever want to have a land trust without the owner or the beneficiary of the land trust being an entity. All right, so let's move on now. So I want to talk now about how trusts work in judgments and liens. Because it's kind of interesting. So a judgment or is something that has where you've gone to court and a judge somehow legally somebody has filed a judgment and the court says you owe somebody or your trustee owes somebody, right? And a lot of times those judgments are placed against a property to make sure that they get paid. So now let's kind of go back to what we were saying before. Since the beneficiary does not have legal or equitable title to the property, a judgment against you, if you're the beneficiary, right, as an individual, is not a lien against the title to the property in the trust. So they cannot put, if a judgment comes against you, it cannot be placed on that property because you do not have legal or equitable title. All right. So it also means the titles that are held in the trust are more readily transferable, so you can move them elsewhere. Okay. So now let's talk about tax liens on you, the beneficiary, right? Again, they're generally not effective in attaching to the title of the property held in the land trust. Okay, same thing for statutory liens. Same thing if a trustee, one of your trustee, has a judgment placed against them. Most of the time, it also cannot attach to that property as the trustee is only the fiduciary of the beneficiary. They're only acting in your interest. So land trusts can help on both sides in case of judgments and liens. All right. Now let's talk about how you can avoid some issues like divorce or partition suits. Okay. So one of the things that is interesting here is that in certain states, the state may require a spouse to also sign a document concerning real property when they're not in even on the title in any way. So those are states that are typically not common law. What am I trying to say? They are where there is where both spouses are entitled to part of the estate, right? So some states say, so say you owned a property before you got married. Some states are going to say now that the spouse has a right to that, even if they aren't on the title. Okay. So in a land contract, if the beneficiary is other than the spouse, and the spouse has no rights to that property, the title to real estate held in a land trust is not subject to community property or other marital rights of the beneficiaries. So that's one of the things that to just understand there. That means that documents dealing with a title can only be executed by the trustee. So it allows for quick abilities to deal with the title of a property, even if there is a divorce. So in divorce, a lot of properties, a lot of assets kind of get held up in a divorce proceedings until somebody decides who gets what. If a property is in a land trust and a beneficiary is somebody other than you, then typically the spouse doesn't have access to that. But the trick here is that it has to be in a land trust before things go sideways, because putting something in a trust after divorce proceedings have already started or things are already starting to go not go well can cause somebody to say that you did that on purpose, which is to get around your legal responsibilities, which just never works. Okay, so let's talk about partition suits. A partition suit typically is a business or some other kind of interest when things are trying to be who owns what. So a petition suit is when somebody is, so think about it in terms of an estate where there are 4 or 5 heirs, right? And they can't agree what to do. And so things can get deadlocked. And one person can hold that up. And the way that that gets undeadlocked a lot of times is either you go to court or you just kind of work it out. Okay. But if a property is in, now again, this is property we're talking about. If a property, or for that matter, personal property is in a land trust or a personal property trust, it goes directly to the beneficiary and it avoids the partition of trying to figure out what 4 or 5 people want to do, right? So it can provide arrangements for holding property through generations. And a lot of times that's actually how some of the very large fortunes are held, some of those things in land and personal property trusts, so that it continue on. You don't have the heirs getting into disagreements about who's to do what, et cetera, how it gets divided up, right? Okay, so this is a kind of another neat one that we want to talk about here, which is when there is a death in the family. Most of the time when there is a death, If there's a will, the property or any assets end up in probate, right? And it takes a while for things to get sorted out once things are in probate. Right. So the way you get around that in terms of land trusts, and to avoid having a something end up in probate. So let's just say that you have property, you have two houses, right? And they are in a land trust. And you are the beneficiary of that land trust. Okay. If you die and there is no successor beneficiary, then that asset ends up, because you're the beneficiary, now you have that personal property trust, that ends up in probate, right? If you have a revocable trust, it goes to wherever the trust says. Okay. So the beneficial interest upon death either goes to probate, or it could go to, it can direct, if you have a beneficial interest with a successor beneficiary, then the trustee just transfers that beneficial interest to the successor. And so if you're going to do land trusts, it behooves you to think about nominating or having a successor trustee in your trust documents. That avoids probate. So it avoids having these properties end up in probate. And they are treated as personal property, right? If there isn't a successor trustee, then it is subject to all the rules of payment of debts and dispositions like any other personal property. Okay, and so you see this, that a land trust can be used to control the disposition upon death, and it avoids probate. So what I just want to show you here is an example. So let's say Kathy is alive and she has put her two properties in a land trust, and the beneficial interest of that land trust is Kathy, and she's named a successor beneficiary. Okay, now Kathy dies unexpectedly. And so immediately on Kathy's death, the beneficial interest transfers to the successor beneficiary immediately. And so now you're avoiding probate, you're avoiding all of those things that can hold up a property and prevent it from collecting money, from paying debts, et cetera, all those things that you can get into if you if somebody dies and the property ends up in a will and probate. Okay, so the last thing I want to talk about here for just a second is another benefit of having properties and land trusts. Okay, so most states, so say you have properties in 3 or 4 states, right? If you have a will or a something like that, and you die, then each state where you're holding real property, the actual property, ends up opening probate in that state for that property, right? And that's called ancillary probate. And it occurs when the property is in one state and the owner is in another state. Okay. So we all know that probate can take, 6 months, a year, 2 years, and they're not free. So what we want to avoid is to having a situation such where you have properties in 3 states and die suddenly, and you don't have some kind of a trust set up, then you're going to be having probate in 3 states. Okay. So how do we get around that? If the property in each of the 3 states is in a land trust, remember, as soon as it's and you or somebody else is the beneficiary, you no longer actually own that property. You have a personal property trust. It's moved from a land trust to a personal property trust. You own the beneficial interest of the property. And so most states have no jurisdiction over real property in another state. So if you have but they have in most states, personal property is generally thought to go back to the state where the person resides. And so having your properties, your beneficiary interest in a personal property trust avoids probate in those other 3 states, right? And because it is generally personal property is generally transferred to where the owner resided. The land trust remains as the owner of the property. And now again, if you have died, or somebody who has a land trust has died without a successor beneficiary, now you're right back in needing to have kind of probate, etc. So I think those are the key things that I really wanted to talk about in related to those 4 items related to why land trusts offer more than privacy and why we really ought to think about doing them. All right. So one of the things I want you to know is that if you want to see more about what we do, you can go to that multifamily webinar, which is Passive Wealth Webinar. Our website is passivecashflowforlife.com. If you have questions or you would like to come to our 4-day class, please email James at support@passivecashflowforlife.com. Okay. We also have YouTube channels where all of these Teaching Tuesdays are located. And we will, this Teaching Tuesday, the information from this Teaching Tuesday will be up on our YouTube channel by the end of the week. Every week we do a call at 6:30 on a various topic. Next week was supposed to be Land Trust 3, but I think what I'm going to do instead is that we're going to do a case study on one of the properties I own and what that kind of looks like. We'll talk a little bit about, kind of just that story and where we are now, and talk about how we figure out what still needs to be done, et cetera, et cetera. And then the following week, we'll come back with the last thing on land trusts. So at this point, let me see if there are any questions. I'm going to stop the recording. I mean, not going to stop, I'm going to stop sharing. And James, do you have any other thing to say? And do we have any questions?
Yeah, Roy G is asked, oops, where'd it go? If one spouse is the beneficiary, other spouse can't claim to that in a divorce situation, question mark?
That's correct. So if you have a property that you want to leave to spouse A, which is a current spouse or a previous spouse, and that person is named as the beneficiary of the land trust, then the current spouse has nothing to say about it. You may end up having some legal arguments, but generally that's pretty settled in most states as I understand it. All right, does Roy still have his hand up there?
No, but Chinny
Yes,
does.
thank you. Yeah.
Okay. But I see somebody else with their hand up.
Yep, go ahead, Chin. Hey,
Hey, what's your question?
I think you're muted still. Bottom left-hand corner of the screen.
Can you hear me now?
Yes.
Yep.
Awesome. Okay. I'm very excited to learn about the land trust. Just to share, I actually create my company structure with a land trust combined with LLC way before I even started. I guess I just got lucky, found this attorney, know how to structure it. So my first question is, have you heard about anybody who combine land trust with series LLC, which each series is kind of considered its individual entity. So basically, my current structure is that when I buy any property, it will be titled under land trust, and then we're the trustee and the beneficiary of that land trust is our series LLC. So that's my first question. And my second question is related to the successor trustee. Is that had to be one person, or it could be like a multiple person, or even like an LLC?
It can be another LLC. So the first question with a series LLC, I don't know enough about series LLCs to feel comfortable answering that question, to be honest with you. I just don't know the answer. I don't think series LLCs are well settled as precedent. And I've just never run into that. So I actually am going to pass answering that because I don't want to give you the wrong answer.
Sure,
In
that's fair.
terms of a successor trustee, we set that up in the trust agreement, and the successor trustee can be another LLC, it can be a partnership, it can be people. The thing that you want to remember in the back of your mind is if it is named as an individual person, that um, if you die or something happens, the LLC typically goes on as long as your operating agreement sets it up so that the LLC continues, right? And whoever was the owner of an LLC continues. So the LLC continues even after you die as a person. And whatever's in the operating agreement now is what drives the decisions. But you can certainly have a successor a successor beneficiary. It's probably not quite as necessary if the beneficiary is an LLC, unless you want to leave your ownership interest in that LLC to a certain person as a successor. And some operating agreements will say that if something, so for instance, with Miranda and I, we have some businesses together. And our operating agreements basically say if one of us is no longer around, whoever inherits our portion of those companies can't make decisions because on it, because we don't know that whoever's going to inherit it knows diddle squat about commercial real estate. And so it's protecting the asset, right? So if you want to have a successor beneficiary named, you can, as a person, Um, and and they step into your shoes of ownership, but the operating agreement that you have put together, because the LLC continues, still holds sway. So I hope that was clear, and if not, come back and ask me again, because I don't want to confuse everybody. Miranda, did that make sense to you?
Are you trying to say that beneficiary, it's basically still hold the asset, but it does not have a control power in terms of like making business decision? Am I understanding that right?
Okay, so because an LLC was the original beneficiary, the LLC continues after you die. And what happens to your ownership interest can be decided by a successor trustee, by a successor beneficiary, but the control that new beneficiary has related to the decisions they can make in that LLC are driven by the operating agreement in that LLC. So if the operating agreement says they can own it, but they can't make decisions about it, then that holds primacy.
I
Does
see.
that,
That's clear. Yeah, that's
okay.
much clear. Thank you so much.
All right. Other questions?
Nothing in chat right now. It doesn't have to
Wayne
be
has-
about trust. Everybody can, oh, here we go. So
Wayne has a
Adam is
question.
asking, do similar rules apply if the property is in a regular trust, especially for a primary family residence?
Okay, so there's a lot of there's quite a bit of literature, quite a number of people who are really good at trusts say you probably shouldn't put your primary residency in a land trust. It does away with some of your insurance benefits, some of your tax benefits. So there are several different kinds of trusts. There is revocable trusts that have all of your assets deeded to the trust, including your house, right? There is non-revocable trusts, which means that you can't change your mind about it. So with a revocable trust, you can change your mind, you can change the trustee, you can change the beneficiaries. With a non-revocable trust, you can't do any of that. There are personal property trusts, there are land trusts. And so when you're talking about trusts in general, you need to talk a little bit about what kind of trust. The most typical trust where your individual house would be placed would be a revocable trust or a non-revocable trust. Most of the time they're revocable, so you can change your mind. And that just means that your house now is deeded to the trust, right? And to whoever the trustee is now actually has the deed to your house. Or that not that person, that the trust owns the house. And so when you die, if all of your assets are in that trust, you don't have to deal with probate at all. You just have to deal with what the trust says to do with the assets. I don't know if that answered your question or not. If not, come back again and let's try that again.
So can the trustee, because the trustee has a legal and legal right on the property, can he act as he wishes, or can he has to follow directions established in the trust, or what the
Okay.
beneficiary says?
So he can do whatever he wants. So he can sell the property. Typically, trustees are supposed to only take directions from the beneficiary. And they are not supposed to they're not supposed to sell. Trustees can sign for debt. They can change the ownership. They could sell the property. And you probably couldn't stop the sell, but now you have a legal case against them where you could sue them for not not keeping your interest at heart, not doing what the trust agreement says. So one of the things we talked about a couple weeks ago when we were talking about trusts in general is that you need more than a one-page trust agreement. So I've seen some pretty pitiful trust agreements out there. You need an agreement that's going to spell out a lot of things. It's actually, think of it as a contract about what the trustee can do and can't do, what they need to check with you on, successor beneficiaries, et cetera, et cetera, et cetera, right? That's why people say when you are finding or signing a trustee, find somebody you trust so that they can't do that. They are not supposed to be able to do anything without your direction, but legally they could.
Okay, thank you.
Other questions?
Wayne has one question. If you own multiple investment properties in multiple locations, do you establish a trust for each property, or can you have one trust and then have that trust be the trustee for all of the individual properties?
That's a good question. So for me, I have properties in 11 states, right? And I have a lot of properties. And so I do not have a land trust for every property. I have a revocable trust.
Okay.
And my holding company, M&A Investments, owns everything, all of the properties. So the ownership of the LLC, the property LLC, is shown to be my holding company. My revocable trust, M&A Investments, is owned by my revocable trust. Trying to put together that a whole bunch of properties into individual land trusts can get to be a bit of an issue. And so once you get to a certain number of properties, I think it makes sense to start thinking about your assets in general rather than each individual property. And at that point, you probably need a revocable trust and having all of the properties owned by that trust rather than an individual land trust. Land trusts are generally one property, one trust. Although you could set it up where, the property, if an LLC owns more than one property, then you're going to get away with it. You can get away with it like that. But at a certain point, you need to be thinking about a bigger picture of your estate and how you handle that.
You
Did that
mentioned,
Go
yeah,
ahead.
it did, and I'm sorry for jumping the gun. You mentioned holding company. What's the significance of that versus an LLC?
Okay. My holding company is an LLC. So M&A Investments is an LLC.
Okay.
By definition, a holding company doesn't own anything specifically, it holds other assets. So almost all of my assets are owned by M&A Investments. All right.
Got it.
And that way, when I set up my revocable trust, all I had to do was to title my
One.
M&A Investments over to the trust. And it also means if I do it that way, that I can buy as many properties and businesses I want, because M&A Investments is going to be the owner of those businesses and those properties. And my trust owns M&A Investments. So I don't have to keep updating my trust agreements.
Got
Did
it.
that make sense to everybody? If it isn't clear, please ask again, because I don't want you to get confused about this.
Yes, it is clear, but do you have any other LLCs under that holding company to hold individual properties, or you just hold them under the holding company?
No, every property, because it's that's a good question. Every property of a certain size has its own LLC. Because if I had my single family properties, so one of the businesses that Miranda and I have together has 20 or 25 houses in it right now, single family houses. And there's one LLC that holds all 25 of those houses. Okay. But those houses are not necessarily really expensive. If I have a commercial property that's worth $2 or $3 million, they're going to have their own LLC. And the reason I'm doing that is because if something happens on one of those 20, 25 houses in one of the LLCs that Miranda and I own, then every house that LLC owns is now up for grabs with whatever happens, because it is owned by the same entity. Are you following that?
Yeah.
Okay. So basically, whether something gets its own LLC, or whether I put more than one property into an LLC, or more than one note or one business, depends on the value. So I don't want to have, so I would start getting pretty anxious if the value of those houses went over $3 or $4 million, for example. I'm going to want to have another LLC started just to limit my liability, particularly when you're talking about houses, because something's going to happen at some point, and somebody's going to sue, right? And now everything that LLC owns is caught up in that suit until it's adjudicated. And I don't want lots and lots of properties caught up in any suit. So I make a decision based on the value of the property, whether I'm going to have more than one property in an LLC, or whether there's one property per LLC.
Okay.
Did that make sense to people?
Yes.
Yes.
Okay.
Do you have your LLC in the states the properties are in, or do you have any state that
Okay.
has a better protections? What is your general?
Okay. So my general is that I'm going to have my for the property, the LLC is going to be filed in the state where the property is. So I'm going to open an LLC in that state. And then my holding company, which is a Maryland LLC, right, owns that LLC from the state. The reason I'm going to generally put the property, an LLC in the state where the property is for instance, Wyoming has great asset protection kinds of laws, right?
Mhm.
But if I own a property in Kentucky, say, and the property in Kentucky is owned by a Wyoming LLC, not only do I have to file in Kentucky, I also have to file as a foreign investor and pay in Wyoming as well. So I'm having a foreign investment fee in Kentucky, and I have to file in Wyoming on that property because it's owned by a Wyoming LLC. So for me, it's just easier to put the LLC in the state where the property is. So I avoid some headaches. Now for businesses, so like James and I, one of our businesses is owned in a Wyoming LLC. Because it doesn't matter where that is coming from. I'm not having to file as a foreign investor because I'm not holding real property in it. So, okay, other questions? We've probably got time for one or two more, and then I'm going to hand it off to Jane and Sharon. James, see your mouth moving. Are
Yeah,
you talking?
just unmuted. While you guys are thinking about it, also, if you have ideas of other subjects that you'd like to learn about on about multifamily on Teaching Tuesdays, or when Jane and Sharon are up next about single family, you can just pop them in the chat. If you think about something later, obviously, feel free to email it to us, because when you think about it, every Tuesday, right? So that's 52 topics. It's a lot of topics. So any help would be appreciated. Any kind of, I guess, subjects that you guys want to learn more about. Even if it's a big subject, we can always cut it up into 2 or 3 Teaching Tuesdays, like we have with land trusts. But again, anything you're curious on, more than happy to take a look at it and see if we can produce some value for you.
Yeah, thanks, James. That's appreciated.
Mhm.
So do you have your revocable trust also in Maryland or any other states?
I have one revocable trust, and it's in Maryland because that's where I reside. So if I were to move to a state that has better laws regarding, kind of death taxes, then I would redo my revocable trust in that state. But I have one revocable trust that holds all of my assets, because I don't want anything having to go through probate. It would just be a pain in the you-know-what. So, and if any of you have significant assets, one of my pieces of advice would just be get a revocable trust. Don't be dealing with a will, because there's a lot of wills are not for people with a lot of assets. They just aren't. They just cause lots of headache, and they tie everything up for a year or more. I see 2 hands up. So 2 last questions, and then we'll turn it over.
I'll go
Go
first.
ahead.
Go ahead, James.
No, I was just saying, go ahead, Shinyi.
I just have a question. When you mentioned, Nichole, just maybe a minute ago, talking about, since land trust is holding the deed title on on the land trust, holding the asset, do you ever run into a situation that when you try to buy, especially like property, I'm sure for all of us who are trying to own rental property, a lot of times it's out of state and it's titled into the land trust. Do you still have to register to do business in that state? Like sometimes when we do LLC, we're trying, if especially coming as external foreign entity trying to do business, rental business in that state, a certain state required to register over there, which incur, more costs. So would this be kind of sort of a creative way, since your title on the land trust, and then it can't really force you have to register because it's not really a LLC's holding the asset. Does that make sense?
So a land trust, the beneficiary of the land trust is almost always an LLC, right?
Yes.
So you have to have formed the LLC. So the question is whether you're forming the LLC in the state where you live or the state where the property is. And I would prefer to have it in, for me personally, in the state where the property is, so I don't have to file as a foreign investor. I just file locally. My personal property trust can be in Maryland or the state where I am, right? So the land trust is typically not focused on a state most of the time. You don't have to file. So you are, when you move the property into a land trust and you're changing the title, then the title has to change in the records, in the state records. And so the owner now appears as a trustee, right? But the ownership of the land trust is typically an LLC, and you would have had to form the LLC someplace. All right, does that kind of answer that?
Yeah, I see. So it's basically still that ultimately the LLC who's holding the beneficiary interest. That's the deciding factor. Is that considered foreign or,
Yes.
in that state?
Yeah.
I see. And this is not a taxable event, right? When you try to transfer
No.
right of on personal to land.
You
Okay.
may have to pay kind of recording fees.
Recording fee.
But you shouldn't have to pay sales fees and all the other things, so it shouldn't be that expensive. Okay, I saw another hand up.
Yes, I wanted to know, is there a reason why you chose a revocable trust versus an irrevocable trust?
Probably that I have a controlling personality, and I don't want to give all my control to somebody else. So a non-revocable trust means that somebody else is making all the decisions. So it has some tax benefits to it. But I can't, I can be the beneficiary, or an LLC or my trust, something can be the beneficiary, but I can never move it. I can never change the trustee. I can never change the beneficiary. I can never change basically anything with that. It's irrevocable. Nothing can change in it. And I'm just not ready to give up all that control, frankly.
With that question, if you did need to change it, what would you have to pull everything out of that trust and just start a new trust to get around that? Or how would you get around that if you had to?
A non-revocable trust?
Yeah.
You can't.
Ever. Wow. Wow. So you can't like pull property out and put it somewhere else if you had to, or
yeah, nope. Whatever that trust owns, it owns. You have you can be the beneficiary, but you have no say about anything.
Oh.
So a lot of people, when they have huge estates, will use a non-revocable trust to avoid some of the tax consequences, because a lot of times it's a charitable remainder trust or some other trust where you are putting your assets to avoid big death tax bills. All right, I think I need to